Hello, everyone, and welcome. This is Bo Jackson, partner in Husch Blackwell's International Trade Group, working from the firm's offices in Kansas City and Washington, D.C. My practice focuses on international trade, including Section 337 litigation, customs matters, anti-dumping and countervailing duty investigations, and trade policy matters. I am happy to be your moderator for today's webcast. Thank you very much for joining us. We're excited to have all of you here and to provide an overview of current embargo and economic sanctions programs that affect U.S. businesses. Before we begin, I would just like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during this program. I'd just like to highlight a few of the key icons for you before we begin. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all of those questions during the webcast today, but if a fuller answer is needed or if we run out of time, it'll be answered later via email. We truly appreciate audience participation, and we encourage you to submit questions. If you have any technical difficulty during the program, please click on the Help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the Resource List icon that looks like a folder at the bottom of your screen. This program has been approved for continuing legal education credit in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas. Wisconsin credit is still pending. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, please click on the CLE widget at the bottom of your screen and complete the questions. Finally, a recording of this webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with your certificate of attendance. Now, with those housekeeping matters finished, I have the honor of introducing our two speakers today, who I'm proud to call my colleagues and partners in our firm's International Trade Practice Group. They are Kollmorgen and Grant Leach. Courtney's in our Washington, D.C. office, and she focuses her practice on the production, sourcing, and movement of goods, services, and technology across international borders. Courtney advises foreign and domestic companies on all aspects of international trade, including export compliance, supply chain efficiencies, investigations, and enforcement. Next, we have Grant Leach from our Omaha, Nebraska office. Grant has extensive experience helping clients navigate complex issues related to international commerce and its associated compliance challenges, with a particular emphasis on helping companies comply with various economic sanctions programs. Notably, prior to joining Husch Blackwell, Grant spent 6 years as in-house counsel for a large multinational company, helping that company on various export compliance issues. So I am pleased to have Courtney and Grant here today to be your presenters. And with all of that, I will now pass it over to my colleague, Courtney.
Thanks, Bo. Welcome, everyone, and good afternoon. Today, we're going to discuss economic sanctions and specifically the various economic and trade sanctions regimes that the United States currently maintains against other countries, entities, and individuals. For those of you that are new to hearing about economic sanctions, we hope that this program will be a useful and timely resource for you. For those of you that may already be quite familiar with economic sanctions and how they work, some of this may be a review for you. However, we hope the information we provide on current U.S. sanctions, recent developments, and best practices will be of particular interest. In the next hour, we plan to cover the following topics: an overview of economic sanctions, a discussion of current U.S. country-based sanctions, recent developments in U.S. sanctions, and best practices for minimizing sanctions risk in global supply chains. Please note, while we do recognize that there's overlap in other U.S. export control regulations, specifically the Export Administration Regulations and the International Traffic in Arms Regulations, this webinar will be focused and limited to OFAC sanctions. We plan to cover the EAR and ITAR export controls in a future webinar discussion. So let's get started. By way of background, governments and multinational bodies impose economic sanctions in an attempt to influence or alter the strategic decisions of state and non-state actors that threaten their interests or violate certain international norms or behaviors. Some critics have indicated that sanctions are often poorly conceived and rarely successful in changing a target's conduct, while proponents contend that they have become more effective in recent years as an essential foreign policy tool. Sanctions have been used by the United Nations, the European Union, and the United States to advance a range of foreign policy goals, including counterterrorism, counter-narcotics, non-proliferation, democracy and human rights promotion, conflict resolution, and cybersecurity. Economic and trade sanctions have been a defining feature of the Western response to various geopolitical challenges, including North Korea's nuclear program and Russia's intervention in the Crimea region of Ukraine. And even as recent as today, President Trump just this morning has indicated that he's instructed U.S. Secretary of Treasury Steven Mnuchin to substantially increase sanctions against Iran in light of a recent attack on Saudi oil facilities. Economic sanctions prohibit the export or re-export of goods and services, including financial services. There are two main types of economic sanctions: comprehensive and targeted. Comprehensive sanctions are those that prohibit commercial activity with regard to an entire country. Targeted sanctions are those that apply to specific sectors, entities, groups, or individuals. While sanctions may take a variety of forms, these can include travel bans, asset freezes, arms embargoes, capital restraints, foreign aid reductions, and trade restrictions. The United States uses economic and financial sanctions more than any other country. Sanctions policy may originate in either the executive or legislative branch and is carried out through a mix of legislation, executive orders, and subsequent regulations. In the United States, sanctions are administered by the Treasury Department's Office of Foreign Assets Control, or OFAC. Other departments, including the State, Commerce, Homeland Security, and Justice departments, may also play an integral role. In terms of country-specific sanctions, or what we call comprehensive sanctions, the U.S. currently maintains sanctions against the following countries: Cuba, Iran, Syria, North Korea, Russia, or the Ukraine, and Venezuela. You'll see Sudan mentioned on that list because until 2018, the U.S. maintained comprehensive sanctions against Sudan. So we wanted to leave that on the list for you to be aware because the statute of limitations runs back 5 years. In terms of Russia and Ukraine and Venezuela, those are noted because the sanctions against Ukraine are really targeted in nature against the Crimea region of Ukraine. There are extensive SDN list and sectoral sanctions against many prominent Russian businesses, officials, and oligarchs. With regard to Venezuela, we consider that a comprehensive embargo because the government of Venezuela controls most of the Venezuelan economy. So it's very hard to differentiate between private interests and public interests. So first we have our first poll question. For CLE purposes, we do a couple of poll questions throughout the webinar. So I hope that all of you will take a moment to participate. This is our first question. Which one of the following countries, regions, is not subject to a complete embargo? A, Cuba, B, Iran, C, Crimea region of Ukraine, D, Venezuela. So it looks like the most popular response was Venezuela, and that is the correct answer, and that is the correct answer. So very well done. Next, we wanted to talk about targeted sanctions or denied person sanctions. The U.S. government prohibits exporting goods or services or making payments to certain persons or businesses on the following 11 lists. These are lists that are maintained by the Commerce Department. BIS is the Bureau of Industry and Security within the Commerce Department. There are also lists maintained by the Office of Foreign Assets Control and also the Directorate of Defense Trade Controls, which is part of the State Department. These lists are often referred to as the consolidated list, and these are lists that, to the extent any of your companies are using commercial screening software, these are the lists that should be being screened. If you are not using commercial software, then you want to be screening these lists through the consolidated list. While the U.S. maintains targeted sanctions against certain individuals, entities, and groups, these are frequently referred to as denied persons or SDN, specially designated national sanctions. The U.S. government maintains a series of lists designating persons or businesses where it prohibits the export of goods or services or the making of payments. The assets of those included on the SDN list are blocked, and U.S. persons, including U.S. businesses and their foreign branches, are prohibited from transacting with those individuals and entities. Under President Trump, OFAC has designated several high-ranking individuals and politically connected firms from Cuba, Myanmar, Nicaragua, Russia, and Venezuela. With regard to blocking sanctions, it's important to keep in mind that OFAC applies a 50% ownership rule, which implicates any business entity in which a denied party holds directly or indirectly a 50% greater ownership interest. Note the key is ownership, not control. Also, if multiple denied persons owned portions of a business, then their respective ownership interests will be aggregated for purposes of applying the 50% ownership rule. While OFAC first addressed entity ownership in 2008, it has issued revised guidance in 2014, which states as follows, quote, any entity owned in aggregate directly or indirectly 50% or more by one or more blocked persons is itself considered a blocked person. OFAC has issued certain frequently asked questions or FAQ guidance on its website with regard to the 50% ownership rule. In this guidance, they urge persons considering a potential transaction to conduct appropriate due diligence on entities that are party to or involved with the transactions with which account relationships are maintained in order to determine relevant ownership stakes. While on its face, the 50% ownership rule might seem straightforward, complying with it can be quite complicated, largely because OFAC does not publish a list of majority SDN-owned entities. Thus, companies should keep in mind when conducting due diligence on customers and counterparties that screening of beneficial ownership of an entity is also a must. At this point, you may be asking, who do OFAC sanctions apply to? On their face, most OFAC sanctions are limited to U.S. persons. However, from a practical standpoint, they also govern a large amount of conduct by non-U.S. persons occurring outside the United States. U.S. persons, for purposes of the OFAC regulations, include the following. All U.S. citizens and permanent resident aliens, regardless of where they are located in the world. All persons and entities within the United States, and all U.S. incorporated entities and their foreign branches. Certain programs maintained by OFAC also require foreign persons or non-U.S. persons in possession of U.S. origin goods to comply with the OFAC regulations, and may limit the re-export of the U.S. origin goods. OFAC also imposes certain secondary sanctions which expressly apply to non-U.S. persons. These will be explained later in greater detail. Additionally, in certain cases, foreign subsidiaries owned or controlled by U.S. companies also must comply with OFAC regulations. Some examples include U.S. employees that have management authority over those foreign subsidiaries, if foreign subsidiaries use support from U.S. subsidiaries, if the foreign subsidiaries are re-exporting U.S. origin goods and services, if the foreign subsidiaries are using financing, insurance, or other forms of support services from U.S. providers. And some sanctions, including the Cuba sanctions, expressly apply to U.S. companies' foreign subsidiaries, regardless of U.S. parent involvement. Next, we're going to delve into some of the country-specific or comprehensive sanctions. So, Grant, do you want to take it away?
Yes, Courtney, thank you for that, and thank you to both for the introduction, and thank you to all of you who are logged into this webinar over your lunch hour, or I guess depending on what time zone you might be in. I'm going to go into more detail on the comprehensive country-specific sanctions that Courtney mentioned during her first part of the presentation. The first country to go over here is Iran, and Iran provides a really good example to showcase the difference between the primary sanctions that apply to U.S. persons and then the secondary sanctions that can apply to non-U.S. persons. If you are a U.S. person, or we'll cover in the second slide, a subsidiary of a non-U.S. person, you are basically prohibited from exporting or re-exporting goods or services to Iran. There are some exceptions there for food, humanitarian items, medicine, and medical devices. Many of those exceptions require you to obtain a license from OFAC. Those licenses can be difficult to get. They can involve a really long waiting time, and they always come with very specific terms and conditions that you have to comply with carefully. But the general rule is, as a U.S. person or a subsidiary of a U.S. person, you are prohibited from transacting with Iran. Then for non-U.S. persons, this is where it gets complicated. The OFAC sanctions require non-U.S. persons to abstain from transacting with certain sectors of Iran's economy. I should say abstain from significant transactions with certain sectors of Iran's economy. That can be oil, financial, shipbuilding, insurance, shipping, etc. And then also, non-U.S. persons have to be careful. In many instances, they have to abstain from transactions with Iranian SDNs. And that includes the 50% ownership rule. This can always get very complicated because there are a lot of Iranian SDNs that conduct significant business operations well outside of Iran. NIOC, the National Iranian Oil Company, is one of those that has a lot of oil field interests well outside of Iran. So as a non-U.S. person, this can be a real bear trap. And then another thing that makes it very complicated is while the U.S. is telling non-U.S. persons that they have to be careful about their transactions with Iran, the European Union, the EU, has lifted most of its sanctions against Iran. So if you are a U.S. person and you're selling to dealers and distributors that are subject to EU law, they might think it's entirely permissible for them to re-export your goods and services to Iran, when in reality that can create some sanctions liability for you. We've also seen this is really challenging if you're a U.S. company and you have services or you're providing some sort of software in the cloud. If you have this server that's in the U.S. or hosted software operated from the U.S., you're providing some sort of hosted service to clients in the EU. If they are turning around and then extending those services to their subsidiaries that they might have in Iran, that's another area that can create this secondary re-export liability for you as a U.S. service provider. This is just a very complicated area of the law, and as Courtney mentioned, the President tweeted this morning that it's going to become more complicated. He's going to even increase our sanctions on Iran. So it'll be interesting to see where that goes. Then again, as I said, the Iran sanctions are unique because they apply not only to U.S. companies, and the direct part of the U.S. sanctions, but those also apply to foreign subsidiaries of U.S. companies. So that can be if the U.S. company has 50% or more of an ownership interest in the foreign subsidiary, if the U.S. company holds a majority of seats on that foreign subsidiary's board of directors, or if otherwise through some sort of corporate financing arrangement, the U.S. company can control the actions, policies, or personnel decisions of the foreign subsidiary, that foreign subsidiary is required to comply with the OFAC sanctions against Iran to the same extent as if they were a U.S. person. This really creates a big challenge when U.S. companies are buying foreign companies, because that foreign company, their entire existence, if they've never had a U.S. owner or organized under foreign law, they've never had to comply with these direct Iran sanctions. But what happens is that after a U.S. company buys them, day one after that acquisition closes, they are subject to the full extent of U.S. sanctions against Iran. So that means if you're a U.S. company buying a foreign company, you need to do a lot of diligence to figure out what sort of transactions they might have with Iran and put together a game plan so you can terminate all of those transactions before the acquisition closes. This is a high enforcement priority area for OFAC, and they were pretty selective about publicizing two recent enforcement actions. One of these was a company called Kollmorgen. This was in February of 2019, and what happened was Kollmorgen acquired a Turkish subsidiary, and they did conduct extensive diligence beforehand and identified that this company in Turkey they wanted to buy was transacting with Iran. They knew that these transactions were going to create OFAC violations going forward, so they told the subsidiary to cancel all of these contracts with Iran before the acquisition closed. In addition to that, Kollmorgen also went in and did pretty robust sanctions training and implemented their compliance program. They worked really hard to prevent this acquired Turkish company from transacting with Iran. But despite all of those efforts, there was one bad apple. One individual employee at Turkey continued transacting with Iran. He wouldn't terminate these transactions. He worked to disguise these transactions to keep the U.S. company, Kollmorgen, from discovering them. Despite their best compliance efforts, what they found out was because of this one bad employee, there were a couple of transactions with Iran that slipped by without them knowing it. They self-reported these transactions to OFAC. OFAC went through the review, actually published this as one of the examples up on their website. Despite all of Kollmorgen's best efforts, they wound up finding them for $13,381, which, all things considered, is a slap on the wrist and was a very good outcome. OFAC publicized this not so much to draw negative attention to Kollmorgen, but because they wanted to make people aware of what sort of diligence OFAC expects you to do if you're a U.S. company and acquiring a foreign subsidiary that transacts with Iran. So the counterpoint there is Stanley Black & Decker, which OFAC published a month later in March of 2019. Stanley Black & Decker acquired a 60% interest in a Chinese joint venture, and that was enough to subject this Chinese joint venture to the Iran sanctions. During this due diligence, they discovered the Chinese joint venture was transacting with Iran. They told the Chinese joint venture to terminate these transactions before the transaction closed, but they never really followed up and verified that this joint venture did terminate those transactions. They started some sanctions compliance training, but they didn't follow through to make sure that the initial employees they trained then went ahead and trained the rest of their direct reports. So what happened was this joint venture continued selling goods and services to Iran. OFAC found out about this because Stanley Black & Decker had been pretty lax with their diligence, with implementing their compliance practices, especially in comparison to what Kollmorgen had done. OFAC determined that Stanley Black & Decker's violations were egregious, and they imposed a penalty of $1.9 million. If you look at the dollar value of goods that Stanley Black & Decker's subsidiary had sold to Iran and that Kollmorgen's subsidiary had sold to Iran, they were pretty similar in value. But you can see here, OFAC let Kollmorgen get away with only a $13,000 penalty, and for Stanley Black & Decker, they imposed a $1.9 million penalty. And that also, I didn't include here in the bullet points, but that also included some ongoing compliance measures where OFAC expected Stanley Black & Decker to implement some pretty expensive and robust compliance policies going forward. So if your company is acquiring overseas companies in this current sanctions environment, it's just incredibly important to do your due diligence and to make sure you're terminating those Iran transactions and also implementing appropriate compliance procedures at those acquired foreign subsidiaries. Now that brings us to Venezuela. As Courtney discussed, Venezuela itself is not subject to a comprehensive embargo, but the government of Venezuela is. Because the government of Venezuela happens to control such a large part of Venezuela's economy, this makes it a real challenging country to do business with under U.S. sanctions. And as you can see here, government of Venezuela is defined very broadly. So that would be any political subdivision, agency, or instrumentality that is owned or controlled by the government of Venezuela. It includes a lot of state-owned businesses. One of those is this company, PDVSA, which was already an SDN. All of its subsidiaries are also subject to these blocking sanctions. And then OFAC has issued quite a few general licenses that allow certain trade to continue with Venezuela. One of these was a winding down license that gave people until September 4th to wind down their transactions with the government of Venezuela. There's also some general licenses out there that permit you to conduct limited transactions related to registering intellectual property in Venezuela, and then also some general license, another one that allows you to continue transactions to keep Venezuela's government-run airports up and running. But those general licenses, they're out there. Like all OFAC general licenses, they come with very specific terms and conditions. So if you do choose to use those general licenses, you just have to read them very carefully, make sure that you're fully compliant with all of their terms and conditions. Another thing to keep in mind with the government of Venezuela, so we've now put that comprehensive set of blocking sanctions on them, but before that, the government of Venezuela was subject to sectoral sanctions, which prohibited you from dealing in any new debt issued by the government of Venezuela with a term of greater than 90 days. The general licenses out there allow you to transact with the government of Venezuela, but they do not lift these debt sanctions for the most part. So even if you are going to transact with the government of Venezuela under one of these general licenses, you need to make sure you're not offering them longer than 90 days payment terms or engaging in any other sort of debt transaction that might be subject to these continuing sectoral sanctions. We have this picture here at the bottom of this slide. One of these gentlemen is on the left, the guy with the mustache. He's Nicolas Maduro. He claims to be the president of Venezuela. The U.S. does not recognize him as the president. The U.S. recognizes this gentleman on the right, Juan Guaido. And we have said that if the Maduro regime makes a peaceful transition of control of Venezuela over to the Guaido regime, then we will consider lifting sanctions. So that's one thing to look out for. I have no idea if or when that might happen, but hopefully if it does, then we can lift these sanctions. Next country to go over is Russia and Ukraine. These sanctions operate at a couple of different levels. Like Venezuela, Russia and Ukraine are not subject to a complete embargo, but OFAC has placed a large number of government officials, oligarchs, and state-operated businesses and banks on the SDN list. Because of OFAC's 50% ownership rule, that actually extends these blocking sanctions to a large number of businesses in Russia and Ukraine. And then the second sub-bullet point here, there's also a complete embargo against the Crimea region of Ukraine. So not the entire country of Ukraine, but just the Crimea region is also subject to a sanctions embargo. Those are the blocking sanctions, the most restrictive sanctions. There's a second category of sanctions against Russia and Ukraine that are the sectoral sanctions. These only apply to certain individuals who've been put on OFAC's sectoral sanctions identifiers list, the SSIL list. That will come with a designation. It will say that they're either subject to Directive 1, Directive 2, or Directive 3 sectoral sanctions. If you're dealing with someone subject to any of those directives, depending on what directives apply, You might be prohibited from making any new equity investment in that company, or you'll be prohibited in dealing in any new debt issued by that company. Depending on which directive applies, there's either a 14-day limitation on the debt, a 60-day limitation, or a 30-day limitation. And like the Venezuela sanctions, this also covers any extension of credit that you might make to one of these sanctioned entities. So if you can still continue to do business and sell goods to someone who's on one of these sectoral sanctions lists, but the catch is they have to pay you within the prescribed timeline. Otherwise, offering credit terms to them is a prohibited dealing in new debt that violates the sanctions. This gets especially complicated if you're not doing a straight sale of goods, but instead doing an installment contract, something that has to be paid out over a series of time. So it's just very important to review those transactions with one of these Directive 1 through 3 entities very closely and make sure your payment terms comply with these sectoral sanctions. And then the other part of the sectoral sanctions is the Directive 4 sectoral sanctions. These are summarized in this bottom bullet point, and these are sanctions that prohibit U.S. persons from exporting goods or services to certain Russian deep water, Arctic offshore, or shale oil exploration or production projects. And these have now been extended where they can potentially cover these oil projects outside of Russia if they're owned by one of the Directive 4 entities or one of their subsidiaries, because the sectoral sanctions, just like the SDN sanctions, are also extended under OFAC's 50% ownership rule. Then most recently, Russia and Ukraine sanctions were also expanded through COTSA, which is the Countering America's Adversaries Through Sanctions Act. What this has done has tagged some of these secondary sanctions onto Russia. If someone has been designated as an SDN for reasons related to Russia, COTSA now requires OFAC to impose blocking sanctions on any person, which could include a non-U.S. person who facilitates significant transactions with an SDN, or also who conducts any sort of significant activities to undermine cybersecurity on behalf of Russia. So this has put non-U.S. companies in a position where they have to monitor their transactions with Russia carefully to make sure they're not transacting with a Russian SDN and also providing that Russian SDN with significant facilitation support. As far as recent developments, in April of 2018, OFAC added 17 different government officials to its SDN list. One of these officials was a gentleman named Oleg Deripaska. His addition was especially problematic because he happened to own a number of very big businesses, one of which was UC Rusal, which is one of the world's largest aluminum producers. Because he was added to the SDN list, that also meant that UC Rusal was subject to these SDN list blocking sanctions. To work around that, OFAC issued a couple of different wind down and maintenance licenses, and they continued to extend those to allow the rest of the world to fulfill pre-existing contracts with UC Rusal. Eventually, in January of 2019, OFAC lifted those sanctions, but they required Oleg Deripaska to divest his ownership interest in those companies, and this created a lot of headaches for people who had pending contracts with these companies. And then also, the other major Russia development during the past year was the Chemical and Biological Weapons Control and Warfare Act, the CBW Act. The U.S. Department of State determined that Russia had violated this statute by trying to use the Novichok nerve agent in an attempted assassination of a UK gentleman named, I believe, Skirple was his last name. The statute required OFAC to impose certain sanctions within a certain amount of time. It gave them a menu of sanctions they could have imposed. These sanctions could have been very significant, but instead OFAC went with one of the least restrictive options and imposed just sanctions that prohibit U.S. banks from engaging in certain financing transactions with Russian government, and those sanctions weren't imposed until 9 months after the statutory deadline, which I just find interesting. Cuba here is the next country to cover. OFAC sanctions continue to generally prohibit U.S. persons from exporting goods or services to Cuba. Like the Iran sanctions, the Cuba sanctions also capture any foreign organized subsidiaries that are ultimately owned or controlled by a U.S. person parent. Cuba does have a couple of licensing avenues available where BIS, which administers the export control EAR regulations, has authority to grant licenses for things like medicine and medical devices, items to support the Cuban people, telecommunication infrastructure. There's another category here that I followed a lot that authorizes BIS to issue exports of agricultural machinery to Cuba to support the Cuban people. The condition there is that you can also sell some of this stuff to the Cuban government, but for one, you need a license from BIS, which BIS may or may not grant, and second, it has to be in a transaction that's going to support the Cuban people. So if you wind up selling a tractor to the Cuban government and that they're going to use it to grow tobacco, that they're going to export in cigars, and the money's going to go and benefit the Cuban people, that won't receive a license. If you're selling it and it's going to grow crops that are ultimately going to feed Cuban people instead of supporting the Cuban government, that might get a license. If you do get one of those licenses, there are provisions in the OFAC sanctions that will also automatically authorize any transactions that are ordinarily incident to the export or re-export of something that's covered under one of the BIS licenses. It's hard to know what exactly qualifies as ordinarily incident, so if you do get one of these BIS licenses, you need to think very carefully about what sort of maintenance or installation services are going to have to go along with that product and figure out if they're covered as ordinarily incident or if you have to apply for a separate OFAC license to provide some of those additional ancillary services. For Cuba developments, very recently in June, OFAC terminated the people-to-people educational travel program. This used to be something that people could go on their own and sort of self-certify their compliance. Then it was scaled back to allow people-to-people travel, but only with a guide under certain terms and conditions. And now, effective June 5th, it's been just completely eliminated. There are still other categories of travel to Cuba that are permissible, but no matter what, if you do travel down to Cuba under one of these few remaining authorized categories of travel, you're always going to be prohibited from engaging in any tourist activities. Also, while you're in Cuba, you also cannot patronize any hotels, restaurants, or other businesses that are on the State Department's Cuba restricted list. That is a list of people that the State Department has determined to be ultimately owned or controlled by the Cuban military, and so you cannot patronize them because that would be profits that would go up to the Cuban military, which is not allowed under our sanctions. And then also, very recently announced, effective October 9th, 2019, U.S. banks are going to be prohibited from processing U-turn transactions involving Cuba. It used to be a U.S. bank could process a transaction if it originated and terminated outside the U.S. Now, even if those transactions originate and terminate outside the U.S., if they involve Cuba, they're going to be prohibited on October 9th. North Korea is the next one here. U.S. persons are also generally prohibited from transacting with North Korea. This includes prohibition if aircraft land in North Korea, they cannot land in the U.S. for a 180-day cooling off period. If vessels call on a North Korean port, there's also a 180-day cooling off period, and that applies to any vessel that engages in a ship-to-ship transfer with a vessel that is called on a North Korean port. OFAC And the secondary sanctions aspect here is that OFAC is looking to sanction non-U.S. persons that continue to support some of these North Korean industries. In some instances, those secondary sanctions are mandatory. In some instances, they're just discretionary, but this is really a very high priority enforcement area for OFAC. Now, so that brings us to the next question. Which one of the following aircrafts or vessels may land in the U.S. or call on a U.S. port? A, an aircraft that landed in North Korea 30 days ago. B, a vessel that called on a North Korean port 120 days ago. C, a vessel that conducted a ship-to-ship transfer within the past 30 days with another vessel that had called on a North Korean port within the past 90 days. Or D, none of the above, saying none of the above are permitted to call on a U.S. port or land in the U.S. So it looks like people are listening along. D is the correct answer. None of those vessels can land in the U.S. or call on a U.S. port under that 180-day cooling off period. That brings us to my last two slides. As far as other sanctions developments that I didn't cover during that country summary, OFAC is just very, very aggressive in enforcing the Iran sanctions right now, particularly in that M&A context. And then also in May of 2019, OFAC issued its framework for OFAC compliance commitments. What this is a pretty extensive document that says exactly what sort of things OFAC expects regulated companies to have as far as a compliance program. It used to be that if you had a good compliance program, OFAC would take that into account and either waive or reduce penalties. Now they're saying that they're also going to go the other direction, that if you do not have a compliance program or if you have an inadequate compliance program, OFAC has put the regulated community on notice and let them know that OFAC will consider that lack of or inadequate compliance program to be a justification for putting you in the highest penalty category for egregious violations, where you get that highest penalty for any violation. Then last, very recently, OFAC has now tagged secondary sanctions on people on the SDN list who've been designated as specially designated global terrorists. What this means is that foreign financial institutions are going to have to screen and make sure they're not knowingly facilitating significant transactions on behalf of these SDGT, SDNs. Otherwise, they could be subject to sanctions that would prohibit them from opening or maintaining correspondent accounts in the U.S. And that brings us to Courtney to finish up the presentation.
Thanks, Grant. Given the vast landscape of U.S. sanctions administered by OFAC and all of the sanctions that Grant has gone over and explained, we thought it would be important to cover some best practices for minimizing your sanctions risk. There are a few standard practices I always discuss with clients to get a baseline view on compliance. First, does the company have a sanctions compliance program? Next, does the company screen their international customers, intermediaries, business partners, and counterparties against the targeted lists we've spoken about before, mainly the specially designated nationals list and denied persons list, and the other 9 to 11 lists that the U.S. maintains. So a key consideration is, do you have an effective compliance program? As Grant discussed, the good news is we do have a roadmap. In May 2019, OFAC issued extensive guidance regarding what constitutes an effective sanctions compliance program. Along with that, the DOJ in 2019 as well also issued an evaluation of corporate compliance programs, which is very similarly aligned and has very similar statements. The starting point for any compliance program is to realize that there's no one-size-fits-all solution. OFAC recognizes that sanctions compliance programs need to be risk-based and tailored to a program's and company's own profile and industry. They have, however, set forth 5 essential components of a strong sanctions compliance program that I wanted to go over with you. The 5 key components of an effective program include management commitment, risk assessment, internal controls, testing and auditing, and training. In general, the new OFAC framework corresponds with the life cycle of a compliance program, commencing with a deep and demonstrated commitment on the part of senior management to creating a culture of compliance backed by sufficient resources. OFAC has indicated that companies should conduct a thorough assessment of their customers, supply chain, intermediaries, counterparties, products, services, and geographic locations to identify potential sources of sanctions-related risk. To prevent those risks from manifesting, OFAC expects companies to develop proper internal controls, including policies and procedures which are regularly tested and updated to address any weaknesses that may be identified. Finally, relevant employees should receive training on the company's sanctions compliance policies and procedures at regular intervals of no more than 1 year. Within each of the 5 components, OFAC provides concrete examples of best practices that companies are expected to follow. For example, when conducting a risk assessment, companies are advised to develop an onboarding process for new customers and accounts, which includes a sanctions risk rating based on both know your customer information provided by the potential counterparty and independent research conducted by the company. Consistent with OFAC's enforcement guidelines, the recent guidance confirms when apparent violations do occur, the nature and extent of a company's compliance program will continue to be a potential aggravating or mitigating factor for purposes of determining what penalty to impose. Another area we wanted to review is diligence for your international sales. Some measures to consider are, do you have proper measures in place for screening international sales against the DIS and OFAC SDN and restricted party lists? Does your company use commercial screening software for this? If not, or if the screening was done poorly, it might be possible to conduct bulk screenings using a third-party vendor. We do, as a practice, strongly encourage clients and companies to use commercial screening software. It especially helps in the next bullet point in terms of screening beneficial ownership for application of the 50% ownership rule. Also, another thing to consider is, do you properly screen your distribution channels? Third-party resellers often create greater risk of re-export and indirect sanctions violations. Do your resellers and distributors understand their U.S. sanctions obligations or your U.S. sanctions obligations and restrictions? Another area of best practice is uncovering and self-reporting violations. So it's important to consider whether your company has measures in place to allow and encourage employees who identify potential violations. Is there a method or means for them to report? Is there an anonymous hotline? Are they able to reach out through senior management to report potential violations? Is proper due diligence being conducted on customers and counterparties? Also, does your company conduct routine auditing of transactions to ensure any errors or mistakes are properly reviewed and reported as quickly as possible? As we've indicated earlier, both OFAC and DOJ provide cooperative credit for parties who self-report violations. Finally, in the OFAC guidance, there's a list of top 10 common pitfalls of sanctions compliance programs. We provide them here for your review. And finally, I think these are here and you can review them at your leisure, but some ones that stick out, obviously a lack of a formal OFAC sanctions compliance program, facilitating transactions by non-U.S. persons, sanctions screening software is inadequate or faulty, improper due diligence on customers or counterparties, and last but not least, individual liability or bad actors within your organization. So in terms of our last poll question, which one of the following is not a best practice for minimizing sanctions-related liability? A, maintaining a risk-based sanctions compliance program. B, utilizing commercial screening software for evaluating counterparties, business partners, and suppliers. C, lack of senior management commitment. D, auditing transactions and submitting voluntary disclosures as needed. So it looks like the majority of people got it right. Lack of senior management commitment. So with that, I think we are at the end of our prepared remarks, but we're happy to take questions from anyone in the audience. And Bo, I think you're going to send those along to us.
Yep, that's right. Thanks, Courtney, and thanks everybody for your attention to this presentation. I hope it's been useful. Certainly been informative for me. Grant and Courtney, we've had a few questions come in, one of which is whether you guys have any thoughts or recommendations for resources that companies can use to help identify 50% owners, and in particular for countries that may lack transparency, and an example given was Russia. So do you guys have any input on that question?
I'll take a first stab at this. I know for compliance professionals within an organization, it seems absolutely impossible to figure out exactly who owns everyone you're dealing with. One good place to start is to check with your internal credit department and figure out if you're already doing some sort of screening within your organization to figure out who is the parent company to the different people you sell to for purposes of getting any sort of a parent guarantee. It might be that your credit department is already looking for this stuff and verifying it in order to figure that out. The second thing is, at the very least, you can modify your documents, ask your customers to certify that they're not owned by an SDN. Depending on the level of risk in the transaction, sort of who you're dealing with, you might want to go a step further and actually engage, either ask them to give you their ownership tables, or if it's a very high-risk transaction, maybe if you're doing something transacting with one of these oil field projects in Russia where it's just very, very important to know exactly who owns them, it might be worth engaging Russian counsel overseas and asking them to kind of do the diligence for you and figure out who owns them. That's very far on one of the most risk adverse ends of the spectrum. There's also different background check services that will provide that information for you. So then one other thing I just thought of here in Russia, many of these companies like Gazprom, they have publicly available financial statements, and you can look through those statements and see the list of subsidiaries. So if you're trying to trace ownership there, that's another publicly available resource that you can try and use.
Great, thanks, Grant. That was helpful, and hopefully the person who posed the question found that helpful. But again, please feel free to follow up with us afterwards if you have additional questions that we can help answer. I think we have time for one, maybe two more. Courtney, I'd like to ask you, you've discussed the importance of screening customers and counterparties as part of an effective sanctions compliance program. But which parties do you recommend companies should be screening in their international transactions?
Sure, thanks, Bo. I think as a baseline, we generally recommend that you screen your customers, but also in foreign shipments and your customers, any intermediaries, but also business partners that you are providing services for on the front end, or if you're receiving goods, suppliers. It can really run the gamut, but at a baseline, customers, your foreign counterparties, but another one that gets missed quite often is intermediaries in the transaction, and really getting a strong handle on the end user and screening that end user and anyone sort of along the supply chain.
Great. Thanks, Courtney. All right. I think we have time for one more, and either of you are free to tackle this one. You'd mentioned that re-exports of goods or services to a prohibited destination or person can also create sanctions violations. So how are companies supposed to comply with those re-export restrictions when oftentimes they have no control over where the third parties might be re-exporting those original products?
I'll give this one a try, Bo. I would say just as a baseline, sort of a bare minimum, if you're dealing with dealers, distributors, and you have them under some sort of agreement, at the very minimum, you should have a written requirement that prohibits them from re-exporting your goods and services to those prohibited destinations. On top of that, something that's very important to do is when you're training your employees on sanctions compliance, you should keep in mind that more often than not, your customers aren't just going to come right out and say that they plan to re-export your product to Cuba or they plan to re-export it to Iran, but there'll usually be some flags there that suggest it might be something like asking you to leave certain fields blank on your shipping documents, or telling you, oh, well, we're going to ship it to this person, but we expect the payment to come from the third party. When you start to see weird details like that, that's something good to train your employees for so they can see that one of these prospective re-export violations is about to occur. And then for a lot of our clients, if as the manufacturer you're selling a product or a service that requires a lot of direct involvement from you, whether it's installation support, whether it's registering a warranty, that might be an opportunity where you would have visibility into some of those possible re-export transactions that then you'd be able to figure out who the end user is and then screen that name against the sanctions list yourselves.
I think I would just add, Grant, I think you covered most of it. I think also sort of the other end, that's getting the information. I would also suggest, and we've seen this in some of the sanctions programs, is if you can't get all of the information you need and you still need clarity, we usually suggest requesting an end-use statement from the counterparty. We've seen that in Russian sanctions. We've seen that in Cuban sanctions, where you're asking, specific provisions of the sanctions for them to attest to that there are no violations there and no potential end use that will controvert the sanctions. So that's another tool as well. If you can't, I would prefer to exhaust all other resources first, but that's another way, belts and suspenders, to do as well. So.
Excellent. Well, thank you, Grant and Courtney, for all this commentary. And most importantly, thank you to our audience and participants for joining us for this program today. We certainly hope that this information was helpful for you and your organization. If you've not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really does assist the firm in providing quality future programs. As a reminder, this program has been approved for CLE credit in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas, and credit is pending in Wisconsin. A recording of the webcast will be available tomorrow for watching and sharing at your convenience. And once available, a link to that recording will be emailed to you along with your certificate of attendance. So this concludes our webinar. Once again, thank you very much for attending, and have a great rest of your day.